How's it going? We're going to talk briefly about the physician-patient relationship. It's a really interesting concept when we look at the differences between, certain legal requirements when you're a patient. But I wanted to share a quick story that I found that was really interesting. Not sure if you've heard of this before, but 1 second, let me pull it up. Fake teen doctor sentencing fraud case. How interesting is that? Apparently this guy was faking his medical license for the state of Florida and was giving ongoing care for 3 to 5 years. He had quite a bit of fraud litigation after the whole thing was done, but as you can tell, he was the president, CEO, and founder of NBNL Medical Center. At 18, that's pretty lofty. So eventually caught up to him, but he got in trouble. But this is why we have laws and regulations out there to prevent these type of things from happening. So the physician's rights, the patient and the physician, or the clinician, of course, they agree to form a relationship and to have a contract for services based on that relationship. The physician does have the right to select patients, and they can refuse service for certain patients, especially if they're not able to give care that they feel is necessary or provocative for the situation that the patient is in. Overall, I think this is a good thing because some physicians, from an ethical standpoint, need to be able to say no during treatment as well. But this is not the case in the emergency department. In the emergency department and urgent care centers, there's a law that we are regulated by called EMTALA, Emergency Medical Treatment and Labor Act. And it requires everyone to be seen. You cannot be turned away from the emergency room or urgent care center. I want to touch on this side. Physicians have to have a continuity of care. So if they go on vacation, if they arrange a vacation, they have to arrange coverage for themselves, or the hospital has to do this for them. They have to have coverage for their patients who are in need during that time, and that's really the most important thing from that slide. Kickbacks in regards to certain things that physicians have to be careful of. You don't want to be paid for taking a patient that was referred to you by another doctor. We've talked about kickbacks. It's in your book quite a bit. Make sure you know in detail what kickbacks are, what law regulates them. Anti-kickback statute. The Stark Law is also another big one you should know. But this ethical standard of kickbacks is taken very seriously, especially in the AMA. So, of course, your license can be revoked if you don't do things the right way. Here's some of the ethical pieces of the AMA that they review on quite often. This says PTA Guide to Ethical Conduct. This is also a slideshow for PTA, but for RAD, you have your ASRT, which is located in the folder under course content. Feel free to look at it. But some of the code of ethics that the AMA has for their medical providers, and then similar for RadTech as well. Some of the professional practice responsibilities are listed here as well. Some obvious ones like duty to not abandon your patient, duty to treat your patients who have AIDS, duty to respect confidentiality. There's a lot there that seems common sense, but sometimes from some people can be overlooked. We talked about that. During emergency, it's always EMTALA, EMTALA. A little bit about not using Wikipedia for sources, but it's like a dictionary. You can always go and find things on there. I don't disregard that. But here's some very interesting stuff about EMTALA. Of course, it started with the United States Congress in 1986 when they passed the Consolidated Omnibusman Budget Reconciliation Act, or COBRA. You probably know COBRA for health insurance reasons. But there's a lot of interesting implications in there about EMTALA. The basis of EMTALA, I think, is justified by wanting to treat patients, not depending on their ability to pay. That's the biggest kicker. So if they walk into the ER, even those who have had reoccurring conditions and might be abusing the ER, you still have to do a medical treatment exam on them to determine whether or not they need medical treatment during that time. You can't, talk about indigent patients or, patients who need more help. Those of you that don't know, that means poor and needy. You can't dump those patients because they can't pay. There's a certain kind of algorithm you have to go by, especially in large hospital systems. They have things called charity care. So it shouldn't matter to the physician. They shouldn't be evaluating whether or not they can see them because of a financial basis. However, if the physician owns their own practice, they can turn patients away based on their medical coverage, and that is legal. Larger hospitals are a little bit different. They're a little more bound by certain things. So they have to keep, patient dumping at a higher standard. They say it's a federal offense to dump a patient, of course, if that's strictly based on the financial implications, but I've not seen a lot of lawsuits from single practice organizations regarding not taking certain patients. Dumping really categorizes it when you take a patient, treating them, and then you get rid of them because they're inability to pay. Most medical practice facilities won't take the patient on at the beginning if they know their insurance is not a good fit for their organization. And that's for, single practice, physician-owned clinics most of the time. You have a duty not to abandon your patient. Of course, you have to follow certain guidelines. Most of the time, it's 30 days notice. But you can give up a patient if it's not a good mutual fit because it is a contract. When you enter into that contract with a patient, you have to be sure to give them an amount of time to find sufficient medical care somewhere else. We can go into detail about this, but a long time ago, this was really an issue. You have a duty to treat people who have AIDS, and you can't deny medical care because of it. When you talk about properly identifying patients, this has to do with personal health information, PHI, or protected health information, PHI. You want to identify people in the correct manner, of course, but this can't be a HIPAA violation if you mix patients up. So keep that in mind as well. You also have a duty to tell the truth. If a patient is going through a really tough time and they have cancer and they only have a couple of years to live, you have to tell the patient that they only have a little bit of time. Being honest is part of the healthcare profession. It's one of the means of the Hippocratic Oath. So telling the truth can be a bad thing at times, but it's something that you're required to do, even if it's a dire situation. Patients' rights, HIPAA, of course the Patient Self-Determination Acts, of course, is living will, durable power of attorney. And I'm sure you know what power of attorney is. You're able to act in conscience for someone else. Do not resuscitate order. You've heard of that before. People have these. A lot of times they wear them as necklaces, or they could be in their medical record. All kinds of information on the internet about this. This is just a basic .gov website. But it talks about what, do not resuscitate means, how do you make the decision, how do you talk to your doctor about it, lots of different information, so really interesting. So these are some of the patient's rights that you have to be aware of. The rights of minors, this is really, really detailed. If you're under the age of 18, you do have medical rights as an adult for certain instances. Part of those: mental health, substance abuse, pregnancy or sexually transmitted disease-related concerns. If you come into a clinic under the age of 18, you can be treated as an adult for that matter, and you can hide that completely from your parents. And I'll give you proof. And care to minors under Washington state law. Minor consent is needed. Parent or guardian consent is needed. STDs, no. Birth control, no. Abortion, no. Prenatal care, no. Outpatient mental health, no. Substance abuse, no. Inpatient substance abuse, yes. Because it's usually for an extended amount of time. They do not even have to share these medical records with the parents. And on top of that, even if the parents are the payers, they don't have to share the records with them. Really, really interesting. Part of the reason is they want to encourage young patients to get treated when they need to be treated without pushback from their parents. Is it helpful? Sometimes, yes. Is it challenging for healthcare providers? Yes, because it can cause issues there, especially with some gray areas. So be careful with that. Make sure you know where to access the information right here, and I will put it up on our course outline so you have it readily available. Patient does have responsibilities. They have to sign a consent form before treatment, and providers should be offering that. You have informed and implied consent. Implied consent would be if you walk into a lab and you're about to get your blood draw, and you lift up your shirt. That's implied consent. It's saying, hey, I'm ready to get my blood draw. A little bit different. Usually have written consent, but that would be implied. Talked a little bit about informed consent. Patient agrees to treatment after being told all the advantages, the risks, and all the potential outcomes. Implied consent is nonverbal communication. When a patient indicates by their behavior that they're accepting the procedure. There's a lot of certain implications that can run into this cause, but routine exams are one of them. There's some exceptions to consent. You can't guarantee success. You can't elicit a cure for every patient. You might not be given back your original state of health, and you have to identify these with the patients. But at the same time, the provider doesn't have to go over every little detail. There's some broad statements they can make to keep themselves safe. You can be in legal trouble if you don't ask for consent before doing something. It's very, very challenging. If you get into a legal circumstance and you've not asked for consent before you did something, it can be seen as a violation to someone's rights, especially privacy. I've heard about Terri Schiavo. I'm not going to go into a lot of detail on this, but this is a really interesting case that you can look at, and I think it's really helpful for us to know that just because we talk about it here doesn't mean it doesn't happen other places. It does happen. It happens quite a bit. So protect yourself. Make sure you know the laws. This is a good start. If you have any questions, furthermore, make sure you reach out to me, and be sure to start preparing for your legal research. It's coming up here pretty soon. So check out the course calendar, the course syllabus, so you know when things are happening. Everyone's doing good in their questions, so keep those up. Make sure you submit them on time, and I hope everyone has a good rest of the week.